Hello and welcome to the Rogers Brief for June 9th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. This week in law, I'm going to cover some international stories and then also some Nova Scotia cases and a couple of stories from across Canada. I'm going to start off internationally, looking at, briefly the Trump indictment. I don't have much information on that yet. We don't have much information on that yet. The actual document, as of my recording of this, has not yet been released, but we have some reports on that. And there's International Criminal Court. There's made some news this week. I'll get into that a little bit. And then a couple of cases out of Nova Scotia to deal with. One is this Better Business Bureau, a former CEO of Better Business Bureau, Peter Moorhouse, and his co-accused, in a sense, Carlos Moreira, who got sentenced this week. There was an attempt also in Nova Scotia to have a class action certified against a dentist who is now under suspension in Halifax, Dr. Errol Gaum, G-A-U-M. The class action was attempted by former patients, and there was a decision released on that this week. I'll talk about that a little bit. And then I'm going to get into the big, Canadian stories this week. There was the transfer of Paul Bernardo, notorious killer, rapist. Paul Bernardo is attempting to, or is being moved, whether he's attempted to, or I guess he requested it, a move from a maximum security to a medium security prison, and that raised a lot of controversy this week. Actually, I spoke to Shay Ganem on the radio in Alberta about this, global radio as well. So I'll talk about that a little bit. There was a story, didn't seem to get much attention, but the Hamilton police are using drones in their police work, and the Canadian Civil Liberties Association has come out with a release condemning that. So I'll mention that, I'll talk about that a little bit. And then there was an article in The Economist this week titled "Generative AI Could Radically Alter the Practice of Law." So artificial intelligence is going to take over and make all of us lawyers obsolete, perhaps, or potentially. So we'll talk about that a little bit at the end. Really interesting stuff. AI is really, in the last year particularly, been a big topic, and maybe nowhere else more so than in legal circles. So I'll get into that a little bit. Interesting article in The Economist this week. Internationally, this Trump indictment, the news of it at least came out yesterday, and this is not, so the first indictment was out of New York, and didn't think it was an appropriate indictment. Anyway, we'll see where that one goes with a grand jury in New York. But this one is to do with his handling of classified documents. After President Trump was no longer president, it was discovered that he had boxes of classified documents that he had in his home in Florida. And so now he's been charged on an indictment with willfully retaining and national defense secrets under the Espionage Act, making false statements about those records that he retained, and then a charge of conspiracy to obstruct justice. So very serious charges here. The first indictment out of New York was to do with, it was a campaign, it was framed as a campaign financing issue, but really it was his payoff to Stormy Daniels, with whom he was alleged to have had an encounter. But anyway, this one, much more serious, federal charges. First time former president has ever been subject to a federal indictment. So we'll see where that goes in the next little while. International news as well, not quite the same, but the International Criminal Court. Many people may not know much about this. International Criminal Court has been criticized as being two things. First of all, not very effective because it has a hard time actually arresting anybody. And also the second criticism is that it's almost exclusively at least, focused on African issues. And this one, The story that came out this week, I saw on Al Jazeera, which was out of the Rwandan genocide of 1994, so nearly 30 years ago. People will know about this. The Hutu minority killed 800,000 Tutsis. This guy, Felician Kabuga, was 90 years old. He claims to be 90. The records suggest apparently that he was 88 years old, is 88. Was living in Paris for a few decades under a false identification. Was extradited to The Hague in 2020. Pled not guilty. Refused to appear or participate in the trial, which has often been the case in the International Criminal Court. Slobodan Milosevic out of Serbia did the same thing, basically. Actually, it ended up in the same place. This guy, the issue, so there's been 62 suspects from the Rwandan genocide who have been convicted so far by the International Criminal Court. So somewhat effective there, but this guy was on the loose for a couple of decades. Apparently made his money in the tea trade and was alleged to have financed the Hutu militias and then allowed or promoted hate speech on his radio station, which covered the country and allowed people to spread the message. He was also alleged to have supplied machetes to the people who were committing the atrocities in the genocide. Anyway, this guy now is 90 and has been declared unfit for trial. So the International Criminal Court, presumably, they didn't go into it, but presumably it's mental capacity, Alzheimer's or something of that nature, and so he's not able to appreciate where he is or what's going on around him, and so in a sense hard to see justice taking place there where the person is not capable of understanding that they are being subjected to the International Criminal Court's version of justice. So apparently, though, the International Criminal Court is going to continue with this trial and prove against him in absentia. May not be a lot different than what the trial would have been otherwise, given his lack of participation. So keep an eye on that and see how the International Criminal Court deals with Mr. Kabuga. Okay. So those are the international stories that have just caught my eye this week. There's some Nova Scotia cases, and this one I talked about I think last week and before as well. And it relates to Peter Moorhouse. Some people may recognize the name from the news. He was the head of the Better Business Bureau in Nova Scotia. He has pled guilty to child pornography offenses, and in his case, he has delayed sentencing, asked for the adjournment of sentencing, waiting for a case from the Supreme Court of Canada to be decided as to whether the 1-year minimum jail sentence for child pornography in his case is unconstitutional. And if it's unconstitutional, he's going to try to claim that in his case it would also be appropriate to not go to jail for his offenses. So I haven't heard a lot about what those offenses are, but now we have a little more of an insight because his co-accused, Carlos Marega, was sentenced to 27 months in jail. And he was charged with two things. One was a physical act, sexual interference, groping a 14-year-old girl. But he was also charged with child pornography and pled guilty to it. Well, the child pornography amounted to, in this case, emails between Marega and Moorhouse, 250 emails back and forth, which were discovered by the mother of the 14-year-old. And they were, graphic emails talking about wanting to assault this 14-year-old and a 12-year-old as well. And they talked about how they could use drugs and alcohol to make it all happen and affect their memories. Didn't actually go through with the what they had been discussing or planning, but the emails themselves, because they are communications back and forth, count as child pornography. So I think this would explain why Peter Moorhouse is awaiting the Supreme Court of Canada decision on the thinking, I suspect, from his side or his lawyer's side at least, that without an actual child involved in creating any pornography, just emails back and forth, which would be not as severe, certainly. that jail time may not be warranted in that case, but we'll see about that. I don't know enough about the Supreme Court case to know how likely it is that the court will strike down the mandatory minimums, but we'll keep an eye on that case. I suspect we'll be hearing something on that in the next few months. Certainly the court in the Moorhouse sentencing is not going to want to delay it much longer than that. All right, so that's the Moorhouse case. I'm going to come back to, actually, we'll talk about the other Nova Scotia case this week, and this was Dr. Errol Gaum. Dr. Gaum is a dentist. He is now had his license suspended by the Nova Scotia Dental Board, the Provincial Dental Board, but there hasn't been any adjudication yet on his on the complaints against him. The complaints are these behavioral management techniques, BMTs, and these involve the attempted class action was a bunch of, I think there was 8 or 9 former patients seeking to have a class action certified, and then at that point they would try to bring in other patients, former patients of Dr. Gaum. And this was rejected by Justice Tim Gabriel of the Supreme Court of Nova Scotia. The class participants, or the proposed class action, was brought forward by Jamie McGilvray of McGilvray Law. People will be familiar with McGilvray Law. If you've watched television, you see the advertisements, they're all over the place. Representing Dr. Gaum was Michael Brenton, who is a lawyer out of New Brunswick. Not sure why there was a lawyer out of New Brunswick brought in for this, or what relationship there may be there. Whether any of this is covered by Dr. Gaum's insurance as a dentist, but anyway, it was a lawyer from New Brunswick for some reason on his side. Now, Jamie McGilvray, a big injury law practice, a growing firm, and I know he's been trying to get into the class action world as well, but which in Nova Scotia at least is dominated mostly by Wagner's, by Michael Dull, who used to be at Wagner's, and by John McKeegan, who's been doing the diocese cases, Antigonish and Halifax diocese cases as class action. So, but a failed attempt here by Jamie McGilvray. The court, they were looking at trying to certify based on these behavioral management techniques, and they were things like what they call shut-ups, hand over the mouth and nose, slapping and hitting, presumably the dentist to the patient, body restraints, leather strap restraints, threats, denied access to guardians, and choking allegations. Now, unproven, unadjudicated as far as the dental board is concerned as well. And so there were some affidavits presented and all these things, but there was some issues. So with a class action, what has to happen is that the class has to have very similar issues, and then it needs to be more efficient to do it as a single case rather than having as a class action rather than having individual cases coming along through the court system. Well, here the problems that Justice Gabriel identified were that the individuals would still have to show their individual claims. And part of the reason is related to the second issue too, which is that standards have changed over the years. Even the expert brought in by the claimants, this is Dr. Peter Kopp, a dentist as well. And Dr. Kopp says that, those standards have evolved over the decades, and these patients are looking at certifying and making complaints from the 70s up to 2020 when Dr. Gaum was suspended. So one of the problems is that the standards have evolved over years. So a patient that was, alleging harm from the late 80s, maybe the standards were, stricter then, or dentists were able to get away with more. Now they have different standards in 2023. Well, that was an issue. Individuals, Justice Gabriel said, would still need to show their individual claims. So there's no necessary commonality to each claim. If one child was told they couldn't see their parent unless they did something, that's different than being hit or having a hand over your mouth. So some different stuff there. The common damages were going to be very difficult to assess in this case, given there's different standards, there's different situations. And then the last thing that Justice Gabriel identified was that there's a limitations issue here. So adults would have 2 years to make a claim against a dentist for any harm alleged. Children would have a different set of a different limitation. They, upon becoming an adult, then they would have the limitation period would start. So some of the claimants may be already beyond their limitation period. We need to argue for that, and some would still be within the limitation period. So there's some distinctions there. Too many distinctions in Justice Gabriel's view to make this a class action. So that those claims. So from the lawyer's perspective, or the class perspective, trying to get a class action going can be very lucrative, because you get a class action and all of a sudden, people who had a complaint against Dr. Gaum and just didn't feel like going through the process by themselves, well, it's so much easier to join a class. All right, you say, all right, I'll join a class action, sign on, and you don't have to do very much to have your claim heard, and then you get to benefit from the whatever the settlement may be, the insurance settlement typically. Lucrative for the lawyer too, because you get the percentage of that total rather than a percentage of just a few claims. But in this case, they didn't build a strong enough case in order to have the class certified, and it wasn't done so. So that will have to proceed on an individual basis against Dr. Gaum if they indeed do proceed. All right, big story of the week in in Canada was the Paul Bernardo case. And Paul Bernardo is 58 years old now. I don't know if people, anybody that's sort of 40 years old or older will certainly remember this. It was the Scarborough rapist, 1992. This guy, he raped, killed, tortured Kristen French, who was 15 at the time. Leslie Mahaffey was 14 years old. This was in St. Catharines, Ontario. Videotaped some of it, and later admitted to 14 other rapes. So worst of the worst in Canadian criminal history. He's certainly one of the worst that has come through the system here. So he's been in a maximum security prison since then, since his sentencing in 1993. So 30 years. Well, after 25 years, you become eligible for parole. And then every 2 years thereafter, you have the right to a parole hearing. Well, Bernardo has had 2 parole hearings, and in both cases, he was denied very quickly. In the first case, I think it took a half an hour for the board to come back with a decision. In the more recent one, I think it took them an hour. Anyway, very short amount of time to make a decision. And the more recent one, they said that Bernardo has limited insight into his actions still, that he has not completed any programming, and that he presented no release plan. So an easy decision not to grant parole in that case. Well, so what's going on here? I think, so the jail in Quebec, the medium security jail in Quebec to which Bernardo is seeking to be transferred, or where the plans are for him to be transferred, has it's known for sex offender treatment. So maybe somebody got through to Bernardo and said, listen, if you want to have any hope of parole, then you need to show that you're trying, and that would involve going to treatment. Well, that's probably the plan. We'll see if he comes through with it. It's hard to imagine that if you haven't done that in 30 years, that all of a sudden you're going to, or that it could be effective in any way. Maybe he'll just try to show that he's getting treatment and hope for that, but I just can't imagine. It just seems like he's never going to get out. So, in practical terms, you talk to sheriffs, anybody in the justice system, there's no distinction in a sense from escapability from a medium versus maximum security prison. So there's no real risk, according to the Correctional Services of Canada at least, of Bernardo escaping from a medium security prison. They have a secured and controlled institution with the same perimeter security as a maximum security prison. This is what the Correctional Services of Canada said in their statement. But they're still under fire for this. Now, Bernardo, in addition to this sentence, has a dangerous offender designation, which means he has an indeterminate sentence. So there's no automatic date when he might get out. It is, the most serious sentence a Canadian court can give. We are not allowed to do torture or executions, but I think when regular people look at this, and I agree with them, it's like, well, whatever the worst thing you can do to somebody is, whatever that is that's allowed, then this guy should get it. And that means a maximum security prison. Uh, if he hasn't engaged in services by now, then is it really necessary to continue to offer any? Arguably not. So we'll see. We'll see what happens here. There's been a review called for. Well, the commissioner, Ann Kelly, her resignation has been called for, certainly by opposition parties and others. But they have announced, Correctional Services of Canada, that there's going to be a review of the decision. So we'll see if that decision even holds. Whether once maybe higher ups or others get a better look at things. So this guy really has. No chance of getting out, but we'll see. So there is just on the torture issue, I guess. People have a right in Canada under the Charter to be not subjected to cruel or unusual punishment, and like isolation, segregation with lights on. These prison conditions can be considered cruel and unusual treatment depending on how it is done. 23-hour segregation, all these things. But I don't think anybody is making a real case that Bernardo is subject to torture in there. Just that he shouldn't be transferred to a medium security prison. So I suspect that decision will be reversed. Certainly Bernardo is never going to get out of jail. The other thing, it just comes up, and I mentioned this on the radio the other day, is that this every 2 years. Is this really necessary? Because what it involves is the French, the Mahaffey family, every 2 years now basically are, well, they're not forced to, somebody else could do it, but they feel compelled to go in and revisit their pain and trauma before the parole board. And, perhaps instead of every 2 years, 2 years is a long time when you're in jail, certainly. But, maybe there's some minimum threshold of, all right, he's engaging in services, he's doing something, therefore he deserves a parole hearing every 2 years. Maybe otherwise it could be a longer time or indefinite. All right, so that's enough about Paul Bernardo and his jail situation. 58 years old, 30 years ago. That was still fresh in many people's minds, I'm sure, that were teenagers or adults at that time. All right, next case, I just want to mention this thing out of Hamilton. This Canadian Civil Liberties Association, it caught my eye, this Hamilton police drone program. So the Hamilton police are urging the expansion of what they call the remotely piloted aerial system, drones, for use for criminal investigations, and they also use it for large-scale events, which the Civil Liberties Association says captures more images than is relevant. So it's, especially when we get into more face recognition capabilities on these drones. So it captures more images than are relevant, and they say will have the effect of chilling protest and freedom of expression. They also say, the Civil Liberties Association, that the police did not consider the privacy impacts of this program, and that they did not even consult with the Ontario Privacy Commissioner before instituting it or seeking its expansion. So anyway, something to watch for. If this goes in Hamilton, one might expect that other police forces would be looking at utilizing drones as well. And for large crowd situations, protests and such, I could see that. Yeah, of course it's going to have a dampening effect on people's willingness to get out and protest. Some people want to protest but don't always want to be observed doing so. So that's an issue that may be becoming more prevalent as time goes on and technology advances. All right, final story. This is an article out of the Economist that caught my attention, and there's been lots written about artificial intelligence in the legal world, and the article is entitled "Generative AI Could Radically Alter the Practice of Law." All right, so there's a story a little while ago about a personal injury lawyer in New York who used ChatGPT for court filing. And he got in all kinds of trouble because the ChatGPT made up cases, made up rulings, and made up quotes, and the lawyer submitted them. Well, what the article, The Economist, suggests is that it wasn't the artificial intelligence that was the fault there. They said this is just like, if you type something into a typewriter and you spell something wrong, well, that's not the typewriter's fault. The lawyer here should have checked the brief before filing it. The Economist calls this a tool in its infancy. Goldman Sachs says that 44%, how do they get that precise number, of legal tasks could be done by artificial intelligence. So things like scrutinizing tedious documents, due diligence by corporations, research, and data analysis. Some of the issues, hallucinations, which is one of the issues. Now, what they mean by that is just exactly what happened in New York. The AI makes up some cases, writes it very well, sounds very compelling, but it's all not factual and made up. So a hallucination brief would be a problem. The other issue was attorney-client privilege, and solicitor-client privilege, we would call it in Canada. And the issue there is that the artificial intelligence isn't going to necessarily distinguish between what should be subject to that and not disclosed in a brief or court filings and what should. And so, always important, even if you have even if you're utilizing artificial intelligence for these purposes, to then review those changes, or review the brief and make appropriate changes and omissions, deletions as necessary. So the Economist article says there's going to be 3 big changes. 1, it'll reduce the big firm manpower advantage. So small lawyer going up against a big firm with a bunch of associates and article clerks that can do research and overwhelm you with documents and such, that advantage will be gone or reduced. Billing. Instead of billing by the hour, which because you'll be able to use artificial intelligence to create documents and analyze documents very quickly, the billing is going to be done more by the job than by the hour. And then thirdly, there will be fewer lawyers. Well, this sounds terrible, I know, but but it'd be good for clients. I mean, this is, when people don't want lawyers, they want solutions. They want resolutions to their problems and or problem avoidance. They don't necessarily want to spend time with lawyers, as lovely as we are to hang out with. So they want to save the expense of that if they can. So it'll be interesting to see. I mean, there'll be lots of people watching these developments. I'll be keeping an eye on it too, just as an interested observer. I haven't used ChatGPT myself for any purposes in any part of my practice, but I could certainly see it going that way. A lot easier to write a 30-page brief if it's already written and all you have to do is edit it. But anyway, that's a little ways to come yet. Okay, anyway, we'll see. I guess I don't know if it would effectively mimic a person's writing style either. Anyway, I'm sure it'll come to that point where we'll be able to if it isn't there already. All right. That's it for this week. Thank you everybody for listening. Thank you for watching, and keep an eye out. So it looks like Sunday night tomorrow. Sunday night, the 10th. The 11th of June. We'll be on. I'll be on with Jordan Bonaparte and Paul Bernardo talking about the developments in the Mass Casualty Commission report. There's been, as I mentioned last week, Justice Linda Oland has been appointed to head up this committee that's supposed to be looking over implementation of recommendations from the report. So there'll be that to talk about. Some other things with the RCMP coming out. Paul Palango sent me a few emails of articles to read, so there'll be lots to discuss. Anyway, we'll watch for that, and otherwise, thanks again for watching, thanks for listening, and we'll see you next time.